Today we're going to talk about one of the most fundamental rights you have as an American citizen, the Fifth Amendment. I'll have more on that in just a moment. The gigantic screw-ups that went into creating the Flint water fiasco produced not only civil cases, but also criminal cases against the parties who made decisions about how to provide water to the city of Flint, Michigan. There were some public officials who were indicted, and then the charges were dropped. It's quite confusing, but in the context of all of this, the Sixth United States Circuit Court of Appeals was asked to decide whether the invocation of the Fifth Amendment could be done after someone had voluntarily testified in a deposition. Here's what the court says in the beginning, and no, I'm not burying the lead here. One of the fundamental liberties enshrined in the Fifth Amendment to our Constitution is the right not to be compelled to bear witness against oneself. The inquisitorial abuses of the Star Chambers eventually led to the inclusion of this right in our Bill of Rights. This bedrock privilege originates from the maxim nemo tenetur saepsum accusare, that no man is bound to accuse himself. In the present case, the district court ordered the appellant state officials to testify at trial, to be witnesses against themselves, despite their invocation of their right against self-incrimination. According to the district court, appellants waived their right not to testify, not to be witnesses against themselves, by voluntarily submitting to a deposition in discovery. We disagree. We conclude the district court erroneously held that testifying at a pretrial deposition waives invocation of their privilege at a later trial in the same civil case. In doing so, we hold the Fifth Amendment waiver does not extend to trial under these circumstances. Thus, we vacate and remand. Basically, what happened is Flint changed from one set of water systems to another. And in that change from one to another, they did not adequately address the issue of all of the lead in the water pipes in the Flint area. And as a result, people not only developed lead poisoning, particularly amongst the children, but they also developed things like E. coli contamination and Legionnaire's disease. None of these things are good, and as a result, there were civil cases brought. Now, civil cases against these government officials were defended by the state. This is an interesting question with regard to what might be called a lawyer ethical question or professional responsibility question. Because what they did was the state attorney general came in and defended these state officials in the civil lawsuit and settled the claims in the Flint water system against the state and its officials. But there were other people who were not officials, who were independent of the government, and they were also sued, and they said, hey, wait a minute, you're not getting out of this so easy. We want those Flint water officials to testify at trial. Well, what had happened was there was a deposition, or there were depositions, I should say, of each of these folks at trial. And here is the important part of that from the actual opinion. Each of the appellants voluntarily sat for a deposition between May and September of 2020. Each appellant was represented by counsel at his deposition, but none invoked the Fifth Amendment privilege against self-incrimination. So, to make matters really convoluted, what happened here is the Attorney General's office originally filed some charges against some of these officials. She later dropped them. A new Attorney General came in and decided to use something unique to Michigan. Michigan had a one-man grand jury proceeding. Well, that absolutely abuses the entire concept of a grand jury, because the grand jury is meant to be a conscience of the community, and you don't put that in one person, because it is subject to abuse, and I mean great abuse. You just basically appoint the enemy of the person you're trying to indict, and you can get a return of an indictment. But be that as it may, this one-person grand jury indicted all of these people. Well, they had testified voluntarily in the civil case, and now when the civil case is getting ready to go to trial, and they now have indictments that are pending against them in the circuit court, in the state court, they say, hey, we're not testifying. We're going to assert our Fifth Amendment rights. And the district court, the federal district court said, nah, you can't do that. You've already testified voluntarily. You've waived your Fifth Amendment protection. So let's take a minute here and deal with this issue. If you have any suspicion that in any respect your testimony could lead to your conviction for a crime, you assert the Fifth Amendment privilege. There is almost never an exception to that. And whoever allowed these people to testify around their privilege seriously screwed this up, in my opinion. So if that wasn't bad enough, the one-man grand jury process in Michigan was challenged, and the Michigan Supreme Court did the right thing. They said, no, that is completely an abuse of the process, and as a result, all of the indictments against these individuals were basically overturned, and they were no longer under charges. But they still were being compelled to testify, and just because the charges were dropped based on this one-man grand jury statute, that did not mean that a second grand jury later on could also indict them. So they were still under criminal jeopardy. As a result of that, they said, we're not going to testify, and we don't care what the district court does. You can throw us in jail if you want to. We are not testifying. But everybody had a different plan, and here was what the different plan was. You can take this up to the Sixth Circuit and see what the Sixth Circuit says. And then, while that was going on, instead of asking them to appear live at trial, the district court played the video depositions at trial, and the jury could not reach a decision. It was a hung jury. A mistrial was declared. So when the Sixth Circuit had this, the individuals who had appealed were no longer under threat of prosecution urgently, and the court first had to decide its jurisdiction. Now, usually when a case is moot, a court will not take up the issue. You may recall the first time the New York State Rifle and Pistol Association challenged the New York statute on transportation of firearms. That particular issue was moot because the New York State changed the law. Well, in very much the same way, the opinion of the Michigan Supreme Court changed the law in Michigan, and now you've got this issue of whether or not there is a moot case here. The Sixth Circuit decided that it wasn't moot. Here's what they said. First, they went over the doctrine of mootness and all of the exceptions to it, and they settled on the capable of repetition but avoiding review part of the exception to mootness. And here's what they said. In this case, appellants contested the order. At a March 25th hearing, the appellants informed the district court they would not comply with the court's ruling and would instead risk contempt proceedings. That the district court did not so hold them in contempt is not their fault. When parties continued to contest a particular order and the district court both functionally stayed that order on its own and permitted an interlocutory appeal, a complaining party's failure to pursue an unnecessary stay does not render the dispute moot. For these reasons, we hold the case is not moot because of its exceptional situation, rendering the dispute capable of repetition, yet evading review. And again, that's taken right from United States Supreme Court jurisprudence. So then the court started looking at the underlying claim, which is the Fifth Amendment. And they said, We begin with the guiding principles of the privilege against self-incrimination. The Fifth Amendment provides no person shall be compelled in any criminal case to be a witness against himself. Under this essential mainstay of our accusatorial, not inquisitorial system of prosecution, the government is constitutionally compelled to establish guilt by evidence independently and freely secured, and it may not by coercion prove a charge against an accused out of his own mouth. It applies to both civil and criminal proceedings, and it protects both parties and non-party witnesses alike. It then went on to discuss what happens when a witness testifies voluntarily, and it said this: this privilege is not unlimited, for a witness may lose its protection by disclosing information. He or she may not testify voluntarily about the subject, then invoke the privilege against self-incrimination when questioned about the details. When the witness testifies, the privilege is waived for matters to which the witness testifies. The reasons for such waiver rule are straightforward. The rule rests primarily on the need to avoid leaving the trier of fact, that's the jury in this case, with a limited version of relevant information that would be before it if a witness was able to pick at will the point at which to invoke the privilege. And then they say, if a witness may pick and choose what aspects of a particular subject to discuss, doing so would inevitably cast doubt on the trustworthiness of the statements and diminish the integrity of the factual inquiry. So that's why a witness, when they take the Fifth Amendment, will generally take the Fifth Amendment about everything. They will do a blanket invocation of the Fifth Amendment. So then the court says, with that issue in mind, let's look at the deposition, whether a deposition and a trial are separate proceedings for Fifth Amendment purposes. If there is a civil trial and you testify voluntarily there, and then later you are indicted, you can still invoke the Fifth Amendment in the criminal trial because the other proceeding was separate. So the Fifth Amendment waiver, if there is a waiver, only applies in the proceeding in which that waiver is made. Now the question is a deposition prior to trial the same proceeding as the trial itself? And the Sixth Circuit ultimately determined that it was not. Here's what they said. The depositions that occurred in this case qualify as one of these testimonial events. In a deposition, witnesses do not have the opportunity to mutilate the truth because both parties have an opportunity to examine the witness. Thus, as a result, the court concluded that the deposition was a separate proceeding from the civil trial, and they would not be compelled to testify live at the trial. But you're probably wondering, well, does that mean the testimony that they gave voluntarily in the deposition doesn't come in? Absolutely not. In that civil trial, the testimony that they gave in that civil trial will come in on a videotaped deposition. And so the court and the jury was not deprived of that evidence. It merely couldn't get them there live. So here's how the court ended the case. In our adversarial justice system, a party has the responsibility to produce the evidence against another by its own independent labors. That's Miranda, the famous Miranda case. The Fifth Amendment is thus grounded on this overriding thought that a witness is guaranteed the right to remain silent unless he chooses to speak in the unfettered exercise of his own will. Appellants here voluntarily waived their privilege by sitting for depositions, and appellees had the opportunity to determine the scope of that waiver through cross-examination. But once that testimonial event concluded, the Fifth Amendment again protected appellants, absent a further waiver. We thus hold that appellants' deposition waivers did not waive the privilege at trial because the waiver never extended, only through the end of cross-examination at their depositions. Therefore, we vacate the district court's order denying the motions to quash and remand for further proceedings consistent with this opinion. But it's an interesting case because it highlights the protection of the Fifth Amendment and how courts tend to believe that is pretty absolute, in that they are willing to make distinctions between depositions and civil trials. That's quite a distinction. I believe probably that in most situations, a deposition in a civil case and the trial in the civil case would routinely be viewed in much the same way. But other legal scholars disagree, and we'll just have to see how this line of case law develops. Anyway, this was a very interesting case that dealt with the Fifth Amendment, and I thought I would bring it to you for your enjoyment. If you have any questions, please leave them in the comments down below. As always, like, share, subscribe. If you know somebody who might benefit from this, please share it with them. Thank you again for watching. Have a marvelous day, and I'll catch you out here next time.